Ms. Escamilla, I guess Roxanne's not here.
She stepped back. Though she did tell me alcohol or THC.
He's still using. Unacceptable. I mean, it's been, I tested you once, you test positive, you test it again, you're still testing positive.
Judge, do we know the quantities and is it just THC? My client says he has not been smoking and I don't know how long it takes for it to come out of his system.
Case has been open since 2022. He's multiple times failed to appear. I've asked him to continually comply with bond conditions, and you've continually over and over and over and over failed to comply. Now your case is 1,010 days old, and you continue to test positive. Right now, you're going to jail. Goes with you. Unacceptable, Mr. Escamilla.
Your Honor, I've not been using.
Test says otherwise. And now at 1,000 days old, multiple tests, you stay with me.
Judge, and to be clear, I just got appointed last time. I haven't been on this case for 1,000 days.
You're
So,
not the first lawyer on this case.
I know, but
And at some point, we have to say when, but it's unacceptable that being 3 years old and now it's over and over.
I think the issue is, Judge, he smoked before the last appearance when he was brought in on the warrant, because he's brought in on a warrant on the new charge. And I think that's the issue. I truly
Given
do.
the sufficient
And so
amount of time,
I know, Judge, but just for me to advocate
I get it.
completely for my client,
I'm
I
not,
know he was on a warrant. I know that he was on bond for that first charge too, but I think it didn't really sink in until the second one. And I've been in contact with him. My staff's been in contact with him. He's trying this time. So what's the,
no, he's going in.
all right, what's the new bond? I'm appointed judge.
I get it.
I know, so he can't have,
Tell
I know,
him that we mean business.
I know, Judge, I'm just
First case is
advocating.
at 5,003, so I'll set that at 7,504 and then 5,001 on the failure to ID.
Say that again, Judge, I'm sorry. And that's my hearing issue.
So the failure to ID is set at 1,000.
Okay,
So on that one, I'm gonna do 5,002, 5,001.
okay. And then the old case,
The old case is at 5,003. So I'll do 7,504.
7504. Thank you, Judge. I'll go talk to him.
So the agreement that you guys have worked out is both, he's got 4 open cases?
He has 4 open cases, Your Honor. The agreement that we worked out was a time served on the failure to ID and the latest criminal trespassing, and they're dismissing a criminal trespassing and interfering with it.
Why, you need to understand something, that you guys can work something out. I don't have to accept the deal. And I am extremely upset with you at this point because I ordered you to get a device. You did not get the device, did you?
I'm sorry, I thought I was actually calling. I didn't know where to get it from.
I told you to get the device. I ordered you to get the device. You did not do anything. And now you are here on a bond violation, not to mention 4 open cases. And now you want me to just take a proverbial slap on the wrist? No. You need to understand, Mr. Musadaki, that actions have consequences. And
Yes, sir.
you not only picked up 4 cases,
I brought my dad here. He's here. Can you come up?
your dad has nothing to do with this and will not save you from this. You have 4 cases and you fail to over and over and over to comply with bond conditions. I will not accept this agreement, and I'm now revoking your bond, and you will go to jail. Goes with you. Unacceptable. Unacceptable. You need to learn that actions have
I've been
consequences.
working.
You today go to jail.
Yeah, can we get a trial setting for Mr. Musaddiq?
100%. Happy to do it. But, you know, the 4 cases, I ordered him to get a GPS, just, they didn't even get it. It's like at what point do we say when? We continually just, Ms. Mendoza, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probably, that remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On March 16th, 2024, Harris County Sheriff's Office was dispatched to 514 Salma Court in Harris County, Texas, for an assault call. The complaining witness reported that her ex-boyfriend's new girlfriend, the defendant, assaulted her. The complaining witness got an email from her ex asking her to meet at his workplace in Harris County, Texas. The complaining witness arrived, and as she was getting out of her vehicle, the defendant ran up to her and started grabbing the complaining witness by the hair and punching her, causing her pain. The complaining witness was trying to clarify that her ex contacted her, but the defendant continued to strike the complaining witness and reportedly tried to gouge her eyes out. The complaining witness's ex-boyfriend was a witness and pulled the defendant off of the complaining witness. The defendant was trying to contact more people to show up and also assault the complaining witness.
Any alcohol or anything like that play a factor in it?
Judge, there's no indication of that, and I've spoke to the complaining witness, and it didn't seem so either.
We have a prior assault from 2 years ago, give or take. Any of these same parties alleged in this prior assault?
Different witnesses, judge, and complainants.
Okay, Ms. Mendoza, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. You're also not allowed to have contact with the other witness in this case as well. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. I will protect my county at all costs. Do you understand?
Yes, but
I'm not gonna, this is not a negotiation. I'm ordering you not to have any contact with either of these people. Do you understand?
yes, it's just that he's my husband though, the witness.
How old are you, ma'am?
I'm 25.
You have the ability to hire a lawyer.
No.
I can have you fill out an application. I'll take a look to see whether you're qualifying. I need to know everything about you, ma'am. I need to know how much money you make, how much money you have coming in, money in the bank, cars, stocks, bonds, mutual funds, and then we'll take a look to see whether you qualify. He's going to give you an application. I'm going to have you sign a receipt with Victoria. We'll have you take your seat in the jury box while we get your bond conditions created. Do not leave until you sign our bond conditions. All right, Deputy Miranda will give you the application.
While the defendants are, can I express some of the concerns from the complaining witness?
Okay, hold on, ma'am.
I just want to make the court aware of everything that's going on. Thank you, Judge.
Yes, of course.
I spoke to her yesterday, and she told me that the defendant's family contacts her regularly, and that the defendant contacted the complaining witness trying to get her to sign an affidavit of non-prosecution. And it's, I believe it's the defendant's boyfriend's mother that's been contacting her is one of her concerns. And she states that she's been threatened civil legal action if she doesn't drop this lawsuit. And the defendant's boyfriend's mom, she relayed to me, actually reached back out to her while I was on the phone with her yesterday and was attempting to contact her. And she wanted me to get with her after this court date.
You are not allowed to have any contact, and I don't want to hear that any other parties are trying to make contact with the complaining witness. If I find that they do, it is you that will be in jail at a very high bond. Do you understand? So reach out to the complaining witness, let them know if they hear anything else from any other persons, then we'll bring them back and then we'll take care of it.
Judge, thank you.
Please, and then if you can file all those conditions.
Yes, Judge.
Good morning, Mr. Gutierrez. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
It's highlighted for
Thank you, Your Honor. On April 28th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a crash and made contact with the defendant and noticed a moderate odor of alcoholic beverage and red, watery eyes. The wheel witness stated that he was inside of his house when he heard a loud bang outside and went out to see a vehicle trying to reverse out of his driveway with the defendant in the driver's seat. The defendant backed into the ditch and the wheel witness told the defendant to stop. The defendant hit the wheel witness's vehicle and a second complaining witness's vehicle. A law enforcement officer arrived and the defendant stated he had been drinking throughout the day. The defendant admitted to hitting both vehicles. A law enforcement officer found an empty beer can on the driver's side floorboard. The defendant was transported to the Joint Processing Center for standard field sobriety tests. A 4 out of 6 was recorded on the HGN, a 4 out of 8 on the walk and turn, and a 4 out of 4 on the one-leg stand. The defendant consented to providing a breath specimen and blew a .094 and a .103.
Okay, any prior to WIs?
No, Your Honor.
License?
I do not have any data populating for the license field.
He does not have a driver license.
Mr. Gutierrez, number one, I'm going to find there's probable cause to go forward with your case. Number two, you're not allowed to consume alcohol or illegal drugs. So I'm going to randomly test you. If I find that you're using, I will put you in jail. No more PR bonds. Number three, you'll be signing an affidavit with me today. Everything I said to the other gentleman applies to you. I don't give a rat's behind what your excuse is. You do not drive. This is an affidavit that you're signing with me, promising me you're not going to drive. If you do, I can have a contempt hearing, and every time you drive, it's an offense in and of itself, punishable by an additional 6 months in jail. Do you understand?
Yes, sir.
Nothing in this life can you justify getting into a car and driving. Nothing. I'm going to have you come up here, swear to us that you're not going to drive. After that, I'm going to get you to Victoria. We will have you sign a reset. After that, you'll get with Roxanne for your bond conditions, and after that, you're free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Ernesto. If he tells me he cannot get a hold of you because you're playing games, if you pick up a new case, if you become a danger to my city, I will issue a warrant, put you in jail. No more PR bonds. Do you understand?
I understand, sir.
All right, come on. Good morning, Mr. Oliver. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Judge. Could I get the name?
Oliver is the last name.
On April 30th, 2025, a law enforcement officer was dispatched to assist an officer on Barker Cypress Road in Harris County, Texas. Another law enforcement officer stated that he observed a motor vehicle make a U-turn and spin its tires. The law enforcement officer followed the motor vehicle into the roadway and observed the motor vehicle to fail to stop at a designated stopping point at an intersection. The law enforcement officer conducted a traffic stop and observed a strong odor of alcoholic beverage emitting from the defendant's breath and person and red glossy eyes. The other law enforcement officer made contact with the defendant, and the defendant stated he consumed one alcoholic beverage at a hookah lounge called Golden Cadillac. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 5 out of 8 on the walk and turn, a 1 out of 4 on the one-leg stand. The defendant refused to provide a breath specimen. A blood warrant was signed and executed.
Ready to be honest.
No prior DWIs, Judge.
Sure. Can you run a full NCIC, please?
Sorry.
Have you run a full NCIC?
I'll run a fresh one, but from what we have here, I'll run a fresh one right now, Your Honor.
Any like reckless drivings, obstructions of a highway, like a reduction
It's just,
in in license?
no, Your Honor, we have a couple previous charges, but nothing related to that.
Okay. License?
License status. It's Your Honor.
Mr. Oliver, I'm going to find that there's probable cause to go forward with the case. I am ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, that includes marijuana, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
License is eligible, Your Honor.
Okay, you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name as well. If you do not have car insurance, you are not allowed to drive, and that is a condition as well. You have the ability to hire a lawyer.
Yes, sir.
If we're going to give you time, I will have you go to Victoria, sign a reset. After that, you'll get with Roxanne for your bond conditions. After that, you'll be free to go. Don't pick up any new cases, Mr. Oliver. Don't be a danger to my community. It will not go well for you. Do you understand?
Yes, sir.
Okay, come on. Good morning, Mr. Ratcliffe. Sir, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 28th, 2025, a law enforcement officer was dispatched to an assault call in Harris County, Texas. Law enforcement officer made contact with the complaining witness who stated she was assaulted by Jamar, the defendant, and a known Bloods gang member at a local food mart. The complaining witness stated she had a verbal altercation with the defendant, which escalated when the defendant threw a drink bottle inside of the complaining witness's motor vehicle. The complaining witness was seated with the door open and one leg out of her vehicle. The complaining witness stated she was going to call 911 when the defendant closed her car door on this complaining witness's leg, causing pain. The complaining witness then exited the vehicle and the defendant began to assault her with closed fists. The complaining witness sustained a broken nose and laceration above her eye, requiring 5 stitches. The law enforcement officer made contact with the defendant, identified by his Texas driver's license, and the defendant stated the complaining witness struck him first. The law enforcement officer observed the defendant to have a black eye, and law enforcement officers note that he did not find the defendant credible regarding.
Did you say that he had a black eye?
That's correct, Your Honor.
Okay. Mr. Ratcliffe, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person whatsoever for any reason. Do you understand?
Sir.
I'm also ordering you as a condition of your bond not to be in possession of weapons as well. If I find that you violate these conditions, if I find that you're a danger to my community, I will put you in jail. No more PR bonds for you, sir. Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we're going to give you time. I'll have you go to Victoria, sign a reset. After that, I'll have you take a seat in the jury box while we get your bond conditions. Once you sign that, you'll be free to go. Ms. Willis, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Judge, on August 22nd, 2023, 2 known employees of a 7-Eleven had stolen $911 worth of lottery tickets from the store. The complainant was stated that at least 9 tickets were missing and that they were worth a total of $911, and that the 2 defendants could be seen on camera removing the lottery tickets from the glass display and scratching them off without paying. The co-defendant and the defendant were engaged in doing this at the same time.
So they're on camera taking it?
Yes, Your Honor.
Taking off?
And scratching the tickets.
Ms. Willis, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to have any contact with any 7-Eleven whatsoever for any reason. If you violate these conditions, you pick up a new case, I will put you in jail. No more PR bonds for you. I'm also ordering you not to have any contact with the co-defendant Walls in this case as well. Ma'am, do you have the ability to hire a lawyer? Okay. I'll have you fill out an application. Deputy Miranda is going to give you one. I'll take a look. I need to know everything about you. Just don't put zeros because I'm not going to believe it. I need to know everything about you. I'll take a look to see whether you qualify. We're going to have bond conditions created for you. Do not leave until you sign them. Okay. Come on. Good morning, Mr.
Buenos
Hernandez
días,
Ramos.
señor Hernández Ramos.
Buenos días.
Let's jail.
Back.
You're on bond for a DWI. You signed an affidavit with me promising me that you would not drive.
A manejar.
And now you've picked up a new DWI.
¿Puedo hablar o no?
Can I speak or no?
You're going to do probable cause on the new case. You have the right to remain silent. They can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Not a problem.
Thank you, Judge. Judge, on May 4th, 2025, officers were at a Shell gas station and observed the defendant near the driver door of his vehicle and observed what appeared to be an open container in a black plastic bag on the center console of the truck. The defendant was visibly intoxicated with unsteady gait, balance, and almost fell attempting to enter his vehicle. Law enforcement officer advised the defendant in Spanish it was probably not a good idea for him to enter his vehicle in his condition, which he acknowledged and did not enter the truck. Once officers returned to their vehicle, officers observed the defendant in the driver's seat of the pickup truck and was seen turning the vehicle on. Officers at this time began a DWI investigation and observed the odor of alcoholic beverage on the defendant's person and breath. The defendant also had poor balance and gait and was having to lean on his vehicle for proper balance. The defendant spoke in slurred Spanish and when asked, admitted to drinking prior to driving. The defendant stated he had drunk 2 12-ounce beers at home prior to arriving at the gas station and had only eaten tacos at approximately 12 p.m. earlier in the day. This time, upon observing the inside of the vehicle, there was no container found in a 32-ounce Modelo bottle that was cold to the touch. The law enforcement officer then carried out standardized field sobriety test and observed 6 out of 6 clues on the HGN. 6 out of 8 clues on the walk and turn. And 3 out of 4 clues on one leg stand.
Question.
Sorry. The defendant consented to a breath test in 0.185 and 0.186.
Where was this? I'm pretty sure you said it. I just.
Shell gas station?
In Harris County, Texas.
Mr. Hernandez, let me express my deep disappointment with you. Not only did you promise me when you picked up the first DWI that you would not drive, not only did you promise me that you would not allegedly consume alcohol, not only last time, like this time, have alcohol in the car while allegedly driving. I would presume that it's damn elementary that you're not to have alcohol in the car while you are driving. Anything you say to me will go in one ear and will go out the other, because I know, given the facts, you refuse to comply with bond conditions. As a result, I am now revoking your bond on the first case and I'm setting it at $25,000. And on your second case, I will do the same. I think that you are a deep and utter danger to our county, and nothing will protect our citizens from you other than Jay. I don't know if you are going to get out. If you do, you were ordered to remain under house confinement. You will have a GPS monitor on your ankle on one, and on your other ankle, you will get a scram device so I know that you're not consuming alcohol. I am now going to decide whether I'm going to have a contempt hearing, because now you could be facing an additional 6 months in jail for violating, or perhaps violating, this affidavit that you signed promising us you're not going to drive. I'm now also ordering you not to drive any vehicle that's not equipped with an ignition interlock. I'm sending notice to DPS in Austin so that every single officer in the state will know if you are caught in a vehicle, it must have an interlock. And if they catch you in a vehicle and it doesn't have an interlock driving, then you will go to jail. Anything that you want to add?
No, Judge.
Anything from the state?
Nothing, Judge.
Okay. All right, Mr. Hernandez. We'll have you come up, swear to us that you're not going to drive again with the new case, and then we'll put you back. Thanks.
Thank you, Judge.
So let's do both at 25,002. Good morning, Mr. Dixon. So you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 28, 2025, in Harris County, Texas. A law enforcement officer initiated a traffic stop on a vehicle that was not displaying a license plate. The law enforcement officer made contact with the defendant and found that his license was suspended. The defendant admitted that the vehicle was not insured.
Judge done. Tests fail.
Mr. Dixon, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason. Do you understand? I don't care what you have to do. I don't care where you have to go. I don't care if there's a burning building and you have to save 50 kids. Do not drive. Do you understand?
Understand.
This is an affidavit that you're going to be signing with me today, promising me that you're not going to drive. Don't do it. I will revoke your bond, put you in jail, and if it warrants it, I can have a contempt hearing. You could be facing an additional 6 months and a $500 fine every time you drive because it's an offense in and of itself. If you want to drive, go get your license, go get insurance in your name, and I will be jumping and doing backflips, taking this restriction off. But if you drive, there will be HE double hockey sticks to pay. Do you understand?
HE double what?
Hockey sticks. Hell to pay. Do you have the ability to hire lawyers, sir? Do you have the ability to hire a lawyer?
Yeah.
Are you sure? Do you want to apply for a court-appointed lawyer? Or do you're going to go hire one?
Yeah.
Okay. If you have any issues, come back and we can talk. I'm happy to give you a court-appointed lawyer if you need one.
Sure.
Okay. I'm going to have you come up here, short you're not going to drive. I'll get you to Victoria Center reset and then you're out of here. Good morning, Mr. Quinn.
This is the one with
Okay.
the
So you want me to
decision
just
maker.
change it here?
Correct.
You got the barcode. Tell me what
first,
happened.
So on the paperwork,
Shh.
On the paperwork.
Okay, so that's fine. Well,
Okay.
or do you want to you don't want to refile it?
But
You
on
wanna-
the
we can
paperwork,
cross
it's
it out?
listed as
okay,
a
Your Honor?
I don't
concurrent
care.
change.
Yeah, whatever's
But our
easy.
agreement
Just
is
as
a
long as we're all on the
decision-making
same
page.
page.
Yeah, I mean, that's just, so you want me to just change it here?
Correct.
You got a barcode first,
Okay,
Okay, so Mr. Quinn, you're charged with evading arrest or detention. You worked out the agreement, they're offering you 6 months. You don't want to refile it? This is a great deal where if you
Is that okay,
complete it
Your Honor?
successfully,
I don't
you do not
Yeah,
end up
whatever's
with a
easy.
conviction
Just
on
as
your
long as we're
record.
all on the
But
same
you can't-
page.
Yeah, I mean, that's just, doesn't get dismissed. You merely take a probation. If you complete it
so Mr.
successfully,
Quinn,
you're charged with evading arrest or
end up with a
detention.
conviction.
You
You
worked
need to
out the
understand
agreement,
that
they're
you give
offering you
up-
6-month deferred. This is a great deal where if you complete it successfully, you do not end up with a conviction on your record. But you can't tell people it's dismissed. It doesn't get dismissed. You merely take a probation. If you complete it successfully, you don't end up with a conviction. You need to understand that you give up nearly every right known to man entering into this agreement. And if you violate this agreement by any way, you're looking at a year in jail. Do you understand? If you test
Sir.
positive for dope or alcohol, don't do your classes on time, pick up a new case, don't show up to your meetings. Do you understand?
Sir.
Can you get this done?
Yes, sir.
To complete this successfully, you must do an effective decision-making class, a gun safety class, 30 hours of community service, and forfeiture of the weapon. You have a car.
No.
How are you going to do the community service? How are you going to do you have an ability to get around?
Yes, sir.
Because understand, you can't just say, you know what, I don't have a right, I can't do anything. We have someone else doing a ton of jail time because of that. And you still get this done.
And if I may, Judge, the pastor from Mr. Quinn's church is here with him today. So
Okay?
I don't want to speak on behalf of him, but I think that he will help facilitate getting this done.
Where are mom and dad?
My mom, she outside with the baby.
She what?
She outside downstairs.
She's here.
She's here.
She's in your life.
Yes.
Okay. All right. I'm going to waive all your fees. It's never about the money. It's about you showing up, doing what you say you're going to do, and don't test positive. The number one thing I would say people get racked up on here is because they continue to test positive. They think that they can just continue to use. You're going to get tested. Know this now. You understand?
Sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accuser, right to be arraigned, charged, right to an open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you enter into this agreement, you were stuck with this until you complete it or it gets revoked. I'll make you a deal. If you do well, you don't test positive, get your stuff done quick. I'll take you off in half the time as a reward. But if you do wrong, it's, do you understand?
Sure.
All right, good luck. Mr. Quinn. Thanks.
David Bases?
Please.
I have Alexander Gallegos. We were on the docket Thursday. He sent up a new DWI. He was on bond
Okay,
for the DWI. He revoked first bond.
is he here now?
He's here now.
Okay, come up, Mr. Gallegos.
He has the scram and the GPS, but his curfew on the GPS ends at 9. He works at the Balboa Surf Club, where he works until like 11 or 11:30. So I was wondering if he
I'll
could.
give him some time, but I don't want him out at night. I don't want you out at night. I don't trust you. You have 2 open DWIs, Mr. Gallegos. You're gonna have to work something out, but I don't want you out at night. I'll give you till 10, but I'm not giving you till midnight.
I'm not driving.
I hope above everything else in this life, you understand that if I catch you driving, all hell is gonna break loose. It's just don't drive.
I understand.
Do you understand?
We do like 11.
Repeat DWIs. Judge loses trust.
How far do you live from the place that you work?
17 minutes from there to my dad's.
And it's 11:30, and then I gotta close up this, 10 o'clock it is for the time being, until I can trust you. You picked up an EWI, you picked up, yeah, allegedly have an accident as well. I don't want you out at night. 10 o'clock is what it is. Does he have a scram on the other ankle?
He does. He has a scram on one and a GPS on one.
Know what you put in your body, because if you put anything in your body that tests positive for alcohol, it's really not going to go well for you. Do you understand?
Sir.
And then can I do a regular reset with both of them together?
Yeah.
Okay.
Hold on a second. I have a no driving affidavit on one. Did we see if I put both cause numbers on it for the driving? I did not. I need you to sign another affidavit promising me you're not going to drive on the other one. And I'm telling you, if I find that you do, I can have a contempt hearing, and every single time you drive, it's an offense punishable by up to 6 months in jail and a $500 fine. If you drive 5 times, I will have 5 contempt hearings. Do you understand?
Sir.
Did we do a guardian? Does he have the guardian analog paperwork?
Because you still have it in your car, don't you?
Still in my car.
We need to-
Okay, you need to understand that every officer in this state knows that if you're driving a car, you must have an interlock on it. So if you're caught driving a vehicle that doesn't have an interlock, you get pulled over, you will go to jail. Do you understand?
I won't be driving.
Okay, all right, yeah, we'll give you a normal reset. We'll have him swear to this, and then you guys are good?
Okay, great.
Okay,
Do you
thanks.
want him to remove the analog or keep it?
We'll leave it in,
Okay.
just so I know that he's not driving.
Okay.
It's on there, Judge, for
Yeah.
the case.
I mean, I'm paying for it, so there's no,
Okay.
I'll waive the fee, so it's not costing him anything.
Judge, for the old case, we're just tracking it with the 2.
With the new case, yeah, with the 2 new cases, and then we'll,
Well,
yeah. Mr. Rivas, you're charged with having a false driver's license. You are facing up to a year in jail and/or a $4,000 fine. You have worked out an agreement. They're offering you 3 days in jail with credit for the 15 days that you have done. You need to understand that this charge will go on your record. It will be there for the rest of your life. You need to understand that from now on, you're facing a minimum of 90 days in jail. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this.
That's fine.
Is this how you understand the agreement?
Yes.
I'm going to tell you that we gave you a PR bond and you failed to appear. As a result, the warrant was issued, and now you have an immigration detainer. From now on, if you pick up a criminal case, show up to court, because when you do, it's a good thing. You understand?
Yes.
And he plead to this offense, guilty.
¿Cómo te declaras? ¿Culpable o no culpable? Culpable. Guilty.
I'm going to find you guilty. I'm going to send you to this agreement. I will roll your court costs so you won't owe anything. Good luck to you, sir. All right, wait, please. Thank you. So this is Mr. Nansien.
Correct. Good morning, Judge.
Just so full transparency here, I clicked the wrong box. So it was charged right, it's right in our system, I just clicked the wrong box.
It's not a big deal. It happens. Worst things will happen. Sir, you're charged with, I think you said 2 cases, right? He's got the terroristic threat.
In an ABI, that's correct, Judge.
The assault is going to be dismissed in exchange for his plea on this one?
No, Judge, I understand there's a time served on both the misdemeanors and it was a reduction of the felony to a misdemeanor. It was part of a global deal.
And that was part of a global offer, Your Honor.
1 second. Because I only have one. I was put my page and go ahead and speak.
Are you guys ready to go forward in the assault?
Your Honor, we only received one, set of plea paperwork.
Did you file on the assault? Is the same deal though? 30 credit for 13 on both?
Okay, yes, that's correct, Judge.
Okay. Mr. Nansien, you're charged with 2 cases. You're charged with terroristic threat, serious bodily injury. On that one, you're facing up to 6 months in jail and or a $2,000 fine. You are also charged with assault causing bodily injury. On that one, you're facing a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 30 days in jail on both of those cases with credit for the 13 days that you have done on both of those cases. You need to understand that after today, both of these cases will reflect as convictions on your record. So you are now facing a minimum of 30 days in jail on any new Class Bs that you get. If you pick up any more Class As, it's a minimum of 90 days in jail. Do you understand?
Yes, Your Honor.
Not only that, on the terroristic threat, if you continue with the same course of conduct, it's very possible that they hit you with a felony charge. So whatever it is, I would be very careful because you could be looking at some serious prison time. You understand?
Yes, Your Honor.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can't change this. Is this what you want to do?
Yes, Your Honor.
How do you plead to both of these offenses? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to send you to both of these agreements, roll your court costs so you won't owe anything. Now, we spoke about this earlier, is he has 2 holds out of Kimball County. So at this point, you will not be released. What will happen is we're going to wait to see if Kimball County comes and gets you. If they don't come get you within the 10th day, at that point, a PR bond will be given to you. But I'm going to tell you now, those warrants, those holds, those cases will always remain open until you go back to Kendall County and take care of it. So anytime you ever get picked up, you're going to get a hold and it's going to be an extra 10 days to whatever happens until you take care of those cases. Do you understand?
Yes, Your Honor. Thank you.
Good luck, man.
Thank
you. Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 24 days in jail with credit for the 8 days that you've done. You need to understand that after today, this will reflect as a conviction on your record. It's going to be there forever. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand?
Yes, sir.
You also give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. So once you plead guilty, you can never change this.
Yes, sir.
Is this what you want to do?
Yes, sir.
How do you plead to the offense or guilty?